Thank you for the kind introduction, and to the New Zealand Law Foundation for bringing me here, and the organizers for including me in the program. So what I'm supposed to do, or want to do, is familiarize you with the CISG as transnational rules, framework, and use in practice. I should like to do this in 3 steps, which will pretty much turn out to be a spurt through the convention. First, I'd like to outline the general framework before then turning to some of the basic concepts of the CISG and ultimately make some brief comments on the use in practice. Now, in the first step, outlining the general framework means I will give you some facts and figures, familiarize you with the basic content of the convention, and then say something about the language and the style in which the convention has been drafted. In terms of facts and figures, Professor Schwenzer has made a couple of these remarks already. The CISG has 78 contracting states as of today. According to WTO 2010 statistics, the 9 largest export nations are contracting states. As of December in 2011, 5 of the 6 major trading partners of New Zealand are also contracting states to the convention. The CISG, finally, is a treaty of public international law, which means contracting states must apply it unrestrictedly, which is only different if the convention itself makes such an exception. These, I think, covers the basic facts you need to know about the convention. Turning to its basic content, the CISG consists of 4 parts. Part 1 in Articles 1 to 13 covers the sphere of application and contains some general provisions of the CISG, which in detail means Articles 1 to 6 autonomously determine the sphere of application of the convention. This means that the states can influence the scope of the convention only where the convention specifically allows this. It is therefore not possible for states to interfere with the sphere of application, for example, by adjusting conflict of laws or any procedural rules. Articles 7 to 13 then contain provisions on the interpretation of the CISG itself, on the interpretation of declaration and contracts, practices and trade usages, as well as form issues. Moving on to Part 2, there we find the major part of the formation provisions in Articles 14 to 24. Now, obviously, in substance, these are rules of general contract law, not core sales law. And before the CISG came into existence, there were 2 separate conventions, namely ULF and ULIS, the former governing the formation of international sales contracts, the latter containing the core sales provisions. Now, since the CISG now also has a formation part, the CISG has brought some progress to legal transnationalism in that we now have one single instrument governing the formation of the contract as well as the core provisions on the sales law. Part 3 then, in fact, deals with the actual sale of goods, which is then the largest part, Articles 25 to 88. Now, this includes the making and taking of delivery, the conformity of the goods, as well as the buyer's obligation to examine them and give notice of defects, the transfer of risk, as well as the remedies for breach of contract, which includes the calculation of damages, the exemption, and the unwinding of the contract. Finally, Part 4, Articles 89 to 101, contains the final provisions of the CISG. Now, this addresses the relationship to other international instruments. The New York Convention has already been mentioned today as one which might, in some aspects, where the relationship might need to be clarified. There are reservations in that part which states may declare towards certain provisions of the CISG. There are some provisions on the accession process that the states can make before becoming contracting states. And finally, the temporal sphere of application is also addressed in that part. So much for the basic content. As regards the language and style, and this is important to me because when you look up the convention, even if you're working with it for the first time, you will quickly discover that it has been drafted in a very simple and clear language, and that the drafters of the convention have opted for an autonomous terminology, meaning they have chosen legal terms that at least avoid domestic connotations. One example is that when a party walks away from the contract following breach of the other party, this is termed avoidance, not termination, as in the common law systems you may be used to. Otherwise, the drafters tried very hard and achieved great results in bridging domestic differences. In the old debate of whether provisions should be briefed or detailed, the CISG makes compromises. An example is Article 35, which is the core provision on the conformity of the goods, which is definitely shorter than the Sale of Goods Act or the UCC, but considerably longer than traditional civil law rules to the same effect. In the old battle between general clauses and specific clauses, the CISG also has found a middle ground, in the sense that, of course, you have general clauses, or in my opinion only one, namely Article 25, which in very broad terms describes what a fundamental breach of contract is. However, in my opinion, it's the only true general clause you can find in a convention. On the other hand, we have also very specific clauses, which is, for example, Article 8. This is a provision telling you about how to interpret contracts and declarations. It contains a clear pattern as how to proceed in the interpretative process, and it also contains a clarification regarding the reference points for interpretation. For common lawyers, it is interesting to note that the provision specifically clarifies that subsequent conduct after the conclusion of the contract may be used in interpreting the original agreement. Furthermore, the CISG only makes moderate use of legal definitions. Examples are Article 13 and 25. 13 is a rather outdated one because it names some electronic communications which were modern at 1980 and which you cannot, I think, even use today, but still they're in there. And again, Article 25 defining what a fundamental breach of contract is. This is the first step. Second step, saying something about basic concepts of the convention. One pertains to the sphere of application, one to the conformity of the goods, and finally some remarks on the remedies that you can find within the CISG. Now, as regards the sphere of application, it is obvious that the CISG intends to apply to contracts for the international sale of goods. In Article 1, Para 1, we only find the denominator contract for the sale of goods. There is no definition within the CISG, but from the obligations that the convention establishes for the parties, we can derive that this means the exchange of goods and transfer of title against the price. Now, this general finding or understanding of contract is then supplemented by Article 3, which first addresses contracts for goods to be manufactured. Now, also these are generally subject to the CISG unless the ordering party supplies a substantial part of the production materials necessary to actually manufacture the goods. This means that the variety of domestic solutions that have been developed to distinguish contracts for sale and contracts for work and materials or supply contracts or whatever term you may wish to give are irrelevant for the CISG with one single criterion, which also means that the results achieved are very predictable. Secondly, Article 3 also addresses mixed contracts, and I'm primarily thinking of contracts which also contain a service element. Again, these are generally subject to the CISG unless the service element forms the preponderant part of the obligation. This means that the parallel application of different areas of law, as is usually done at the domestic level, whether you call it a gravamen of action test, or whether you say, I will use simply service law applying to service contracts for this question and another one for this question. This whole patchwork of laws is evaded by the CISG by simply establishing the criterion: if the service element is not the preponderant part, it's simply a contract of sale. So again, the result is predictable. Furthermore, the CISG has no hierarchy of obligations. This is something that is especially important for a civil lawyer, because there the distinction of main and ancillary duties is particularly strong, which does not apply under the CISG. And even more subtle domestic distinctions as to protective ancillary duties and performance-related ancillary duties are also irrelevant. That all has the same meaning and status under the convention. It is simply a contractual obligation. So in essence, the convention has a very broad concept of sales contract and provides very clear guidance with regard to the classification of cross-border transactions. Turning to conformity of the goods as the concept stands within the CISG. And here the central part is the understanding of conformity as employed by the convention. Now there are a number of domestic distinctions, traditional ones, which are irrelevant under the CISG and thus make it very simple to work with. Express and implied warranties, it's irrelevant. Conditions and warranties, it's also irrelevant. Same goes for vis apparent and vis caché of French descent. Aliud and peius, meaning the distinction of the delivery of a defective good and the delivery of something completely different, which can be very hard to distinguish, is also irrelevant under the convention. Whatever the good may be, it's simply a defective one from that which was owned under the contract. Finally, also the gravity of the non-conformity is irrelevant, at least as far as the question is concerned, is the good non-conforming? Whatever slight the deviation, it's a non-conformity. So there's no de minimis or any other kind of class qualification to the conformity issue. Now, if all of that is irrelevant, what is relevant? Relevant is, first of all, the intention of the parties. So it's up to the parties to make a provision in their contract where the quality and the quantity of the goods are defined. Where the parties have not done so or have been incomplete in this regard, then the convention first of all applies a mixed subjective-objective standard, which means the goods first of all have to be fit for the particular purpose for which they will be used. You may recognize this also from the Sale of Goods Act. If this is not the case, or in any other case where a sample has been presented to the seller during the negotiations, then of course the goods must match this sample. Where this mixed standard of subjective-objective considerations does not lead to a result, also the CISG applies an objective standard, which means that the goods must be fit for such purpose as goods of the same kind would ordinarily be used. Finally, the CISG clarifies one issue that always gives rise to dispute in domestic systems, and there is no harmonization in that regard, that adequate packaging is part of the conformity of the goods. Especially when you have to deal with parties from civil law jurisdictions, you will find that most of their laws will not see this as an issue of conformity. A remaining distinction under the CISG is that legal defects and the infringement of intellectual or industrial property rights are distinguished from the conformity in terms of the physical aspects of the goods. Furthermore, the CISG also clarifies that examination of the goods by the buyer, as well as giving notice of these defects to the seller, is always applicable. You may know from civil law jurisdictions in particular that where the goods are being held to be something different than what was owed under the contract, there is no notification duty. So here the CISG is very clear in saying, whatever arrives, if you're not satisfied, you have to report this to the seller. Exceptions are where the seller, in Article 40, could not have been unaware of the nonconformity himself, or where the buyer has a reasonable excuse for not having given notice within a reasonable time. In terms of the remedies that are available for breach of contract, the CISG follows what we call the breach of contract approach, which means there is no separate regime for different types of breach. Every breach of contract triggers the same set of remedies. Hence, for civil lawyers, the old Roman concept of having different regimes for impossibility, delay, and improper performance has been abandoned. More interesting from the common law perspective is that the distinction as to condition or warranty has also not been taken up by the CISG. In the same vein, the concept of acceptance and for the US lawyers in particular, then the revocation of acceptance is not part of the convention. Yeah. Furthermore, there's no legal hierarchy of remedies. Again, in the civil law jurisdictions, you often have the issue that specific performance trumps the other remedies, in the sense that you may have to fix an additional period of time before you can resort to any other remedy. This is not the case under the CISG. So every remedy is potentially available for every breach. And also, whether a typical sales or additional duty is breached is not relevant for this question. The only issue, or where it does matter, however, is that avoidance of the contract and substitute delivery, I'll get to that in a moment, both of them require fundamental breach, which has a very high threshold, meaning that the buyer cannot make use of the goods in any way. Now, if that is the system, then what are, forgot one. The CISG also follows then the concept of strict liability. So the civil law idea of fault has been abandoned and not picked up at any point in the convention. Damages are rather limited by the foreseeability rule, which was easily acceptable both for the civil law as well as the common law. For common law, obvious, it's very obvious, and for civil law because the foreseeability rule originates in the French Civil Code from 1804. Furthermore, exemption is possible in case of an impediment that is outside of the control of the debtor. And exemption is also possible where the obligee himself has contributed to the breach that triggered the remedies in the first place. This is the general system of remedies which the CISG employs. Now, the individual remedies available are damages, obviously, and specific performance in a number of ways. First, the buyer has a claim for repair by the seller, which is mirrored by a right of the seller to effectively repair the goods in case this to the seller seems to be the most efficient or for him most economic way to proceed. The buyer then has a claim for substitute goods, as I mentioned, only in case there's a fundamental breach of contract. So there's an increased threshold to make that claim. Finally, the seller has a claim for payment and taking of delivery by the buyer. Now, since specific performance has always been met with great criticism and skepticism in the common law, the CISG offers a way out for courts. In that court, the court is not bound to enter into any judgment for specific performance unless it would do so under its own law in relation to comparable contracts. This, of course, was at the time a compromise reached at the drafting conference, which was heavily fought, but which in practice has never arisen. That problem, especially that provision, which is Article 28, allowing the court to take an escape route from the specific performance claim, has never been a problem. Finally, the contract may be avoided, again, in case of fundamental breach, and in any case, the purchase price may be reduced by the buyer. These are the individual remedies following breach of contract. This already leads me, and I hope I have some time left. Excellent. I expect it to be down to 2 by this moment. To the use of the CISG in practice, or how it can be put to use, I should say. Now, there's 3 notions to this, at least, and this pertains, of course, to the experience I've gathered so far and what colleagues in comparable situations also working in Zurich law firms have told me. Pertains, first of all, to neutrality, the reduction of costs in 2 respects, I will get to this, and the degree of legal certainty that's been achieved. Now, obviously, with regard to neutrality, you are not in dire need of neutrality in a New Zealand-Australian contract. The legal background is effectively the same, so there's little chance that you feel favored or disfavored by one or the other law. However, out of the previously mentioned 5 major trading partners of New Zealand, which are contracting states, the 3 of them are China, Japan, and South Korea, which are civil law jurisdictions, and all of them with a very, very strong Germanic background. So here the neutrality argument is quite strong. And following from the previous 2 steps, there is no home court advantage to any of the parties, because the language and the style do not prefer one party over the other. Due to the fact that a number of domestic distinctions have been given up, the concepts of the CISG do not prefer one legal background over the other. Furthermore, the CISG demands to be interpreted in light of the international environment, which means that at least as a matter of theory, domestic policies are excluded. And finally, the CISG is accessible to both parties in the same way. This immediately leads then to the reduction of costs. And first, regarding the costs in the contract negotiations. The list of issues to be negotiated is drastically reduced when contracting a CISG contract. Why? The seller's position usually is that there should be no avoidance, or at least, if you cannot exclude it, there should be a high threshold and restricted time periods for the buyer to rely on the breach. The buyer's position usually is that it wants to preserve the right to avoid the contract, at best immediately, has a right to repair or may require the seller to repair the goods, and of course has long periods of time to rely on the breach. And in many instances, the compromise that is reached after long and costly negotiations then corresponds to the default rule that would have been applicable anyway. Because under the CISG, avoidance is not excluded, but the threshold is very high. And the seller can even evade avoidance by the buyer by offering to repair the goods. Finally, the buyer is by default entitled to repair of the goods, which, at least in civil law jurisdictions, is always a negotiating issue, has generally longer periods for notification than under domestic law. I'll turn to that again in a moment. Costs are obviously then reduced in the negotiating process, but they are also reduced in disputes. The CISG is accessible to the parties because most of the materials are available in English. This means court decisions and arbitral awards, but also scholarly writings, which means that translations, which are usually very expensive, are not necessary. Which means that it's easy for arbitrators to work with the CISG and effectively reduces the need for expert witnesses. My final comment. On the legal certainty in advising clients. There are now about 3,000 published court decisions and arbitral awards, an abundant number of scholarly writings, and the typical issues have been decided by courts, which means we can tell the client how to be at least on the safe side. A choice of law clause of a contracting state always leads to the CISG. Offering a price range is sufficient for a valid offer. In first contact, the client should send the standard terms to the other party. If standard terms are in conflict, they will be resolved by the knockout rule. In the sale of durable goods, typically there will be 4 weeks for notice of nonconformity, and there will be no rescission based on mistake parallel to the CISG remedies for nonconformity. If I have 30 seconds to sum up, then I'm through. 10. Okay. So the CISG has transnational rules for sales contracts, has a broad range of application, is drafted in a simple and neutral language, provides for a simple one-path regime of contract, breach, and remedies, is neutral grounds for parties, provides default solutions that usually are at the end of heavy negotiations, and reduces costs in negotiations and disputes. Thank you for your time.